right, good afternoon, which is not something we usually say here at the Court of Appeals. So welcome. We thank everyone for their accommodations on the scheduling. We are here for two arguments this afternoon. I am Judge Oliver and will be chairing this panel. I am joined by Judge Harris and Judge Tenney. The first case we are going to hear is 2023027 Scmidt v. Petersen. And if I could have counsel make your appearances, please.
Julie Nelson for Stephen Scmidt.
Emily Adams for Kyle Petersen.
All right, thank you. I know this is not your first foray here to our court, probably not even this week. So unless there are burning questions, I see that we have 4 minutes reserved for rebuttal, so I will just confirm that is the correct time. And with that, we'll invite you to begin.
Thank you.
May it please the court, Julie Nelson for appellant Stephen Scmidt. In February of 21, someone or someone's created a fake Equifax account using Kyle's credit card to monitor Steve's credit. A charge gets made to Kyle's credit card every single month. Let's be clear, that's a crime.
Do we know how much the charge was?
Like $10.
Is that in the record?
Oh, I think so. I don't have record site for that particular. I could look.
But
Perhaps Ms. Adams could look.
Yeah, the reason I ask is one might pay closer attention to a $100 monthly charge than to a $10 monthly charge.
Well, I understand that, but one might still be responsible for the information that's coming through on one's credit card, regardless of how much it is.
That's
and it
why I
happens
was
for,
moderately curious as to what the amount was. Anyway, go ahead.
and it happens for 22 months. So it starts in February of 21. In the summer of 22, Kyle sends these nasty, profane messages to Steve. Steve doesn't know about the credit monitoring at this time. He files a stalking injunction on the profane messages. Judge Mrazek decides that there's not enough for stalking on the profane messages, in part because he decides it doesn't meet the standard for fear or harm, and in part because we don't know that Kyle took the photo. Sent, definitely, but we don't know that he took the photo. He does advise Kyle to give Steve a wide berth. Meanwhile, neither Steve nor Judge Mrazek know that the credit monitoring is going on. When Steve does discover it, he files another stalking injunction, obviously. He includes in his petition everything in the record from the profane messages. But Judge Mrazek doesn't consider these nasty messages in his analysis, nor does he say why not.
How do we know that he didn't consider them?
Well, he didn't consider them on the record. So here's
What says that he has to enter? What authority says that he has to enter findings about that to show that he considered them? I mean, because let me just put the card on the table, perhaps give you a little bit of thinking time on that question. We have the presumption of regularity that runs through a couple of different areas of law. And one of the ways the presumption of regularity gets used is to say that if a district court is required to consider certain factors, it often does not need to actually say something about each of the factors on the record, and if it's just silent about the factors, we're just going to presume that the court did consider them. So here, one of the things that I'm wondering about on that part of your argument is, yeah, it's true that in his ruling, Judge Mrazek doesn't say anything about the previous incident, but how do we know that he didn't consider it as part of his analysis?
Well, I guess we don't know if he considered it mentally as part of his analysis, but what we do know is this, that Utah law requires, we've got a string of cases that are reversing because the district court didn't consider the full course of conduct. So if we can look at some of that language so we know exactly what is required, I think it'll become pretty apparent that he has to do it on the record. It can't just be like a thing that flutters through his head.
So he's got to walk through each of the prior incidents and he's got to say why they do or do not support the conclusion here?
Well, maybe I can start by saying what he did find and then we can talk about what he didn't address. All right, so I'm looking on page 246. He says, here we had a course of conduct in terms of multiple months of surreptitious monitoring of Mr. Schmidt's credit report. Okay, that's the first element. We have a course of conduct. He says it's directed at a specific person. That's part of the element, Mr. Scmidt. Whoever did it knew or should know objectively that the conduct would cause a reasonable person in Mr. Schmidt's situation, in any person's situation, to either fear for their own safety, based upon being surreptitiously surveilled with respect to their sensitive financial information or to suffer other emotional distress, as that phrase is used and defined in statute. Okay, those are the elements that we think we're supposed to meet. So far, it sounds like he thinks the elements have been met. But then he says, here the issue, the fulcrum upon which the determination in this case balances, is whether Mr. Scmidt has shown by a preponderance of the evidence that Kyle Petersen is the person, not a person, the person who intentionally or knowingly engaged in this course of conduct. Evidence weighing in favor of that is the fact that Mr. Petersen's credit card is the credit card number associated with the Equifax account that was opened to surreptitiously surveil Mr. Schmidt's credit account. But on the other hand, we have Angela, formerly known as Scmidt, now Petersen's phone number attached to that account. All right, he says, we don't have any testimony that Mr. Petersen actually set that account up, which is not one of the requirements. We do have circumstantial evidence that Angela has previously used Mr. Schmidt's credit card number without his knowledge during their marriage, and we don't have any sworn testimony from Mr. Petersen or Angela. And then there's a little bit more. He says, the court finds that Mr. Scmidt has failed to carry his burden by a preponderance of evidence to show that it was Mr. Petersen who engaged intentionally or knowingly in the course of conduct. Skipping forward.
But we're back to my question though. If the first part of your first argument is that he's required by law to have taken into account all these prior incidents, and you're telling us that those prior incidents were put before him in the verified petition, they were alluded to in Mr. Schmidt's testimony, they were directly referenced in argument, why wouldn't the presumption of regularity tell us that Judge Mrazek was fully aware of those prior incidents and just didn't think that they helped?
Well, when we look at the case law, I think he has to have actually explained either why they helped or why they didn't help. I mean, he says it's evenly balanced. In the next sentence, he says it's evenly balanced. It was either Kyle or it was Angela. But it's only evenly balanced if you cut off all of the nasty messages and you exclude all of that. If you put them on the scale, it might not be evenly balanced, but he didn't do that analysis. He just says it's evenly balanced, and I'm not going to say anything about the text messages, but the case law requires him to do it.
Okay, so let me ask you about the case law. One of the things as I thought through this case and I thought through that particular part of your argument that strikes me is, correct me if I'm wrong, I haven't gone through all of them, but it seems like a lot of the cases that you're citing for that proposition say that what a district court is required to do is take into account all of the circumstances to determine the effect on a reasonable person. There's a lot of cases that talk about it in that context. There's at least one case, the Ellison case, that talks about you need to consider them cumulatively to determine whether the course of conduct was directed at the person. But I'm not aware of a case that says that you have to consider the past conduct in terms of determining whether the person actually did this other thing. Is there such a case?
There's not, but what we do have is cumulative conduct in various other aspects. Nothing about the cumulative conduct language is limited to any particular section. We're seeing it broadly. So
I mean, it feels a little troubling to me analytically. It's almost got shades of a 404B problem to say that because you engaged in this past bad conduct, we're then going to use your past bad behavior to inferentially suggest that you actually did this thing this time too.
well, but I think that that's what the case law is getting at. I mean, we've got case after case after case saying you've got to make a holistic instead of an insular analysis, right? You've got to look at the cumulative context. You've got to look at the entire context surrounding the situation. You've got Supreme Court cases. You've got Court of Appeals cases.
But again, that's my point though, is that those cases, correct me if I'm wrong, but those cases seem directed at the idea of whether the effect on the person would be such. So we're going to look holistically and cumulatively to sort of figure out what the collective effect is going to be on the person. But do any of those cases say that a district court is required to say, because you did bad thing A, bad thing B, bad thing C, that's going to help show that you actually did bad thing D, right? And why wouldn't that be different analytically?
Well, I'm going to also turn to State versus Miller. Paragraph 116 says that the prior conduct remains relevant to understand the parties' relationship and the history they shared. I mean, if Judge Mrazek thought that this incident that he found, he had recognized that it was, speaking of the text messages, it was a course of conduct, but it didn't quite rise to the level of harm, and he advised Kyle to give him a wide berth, and then we come forward and we're like, okay, well now we do have the harm, and we know that we have a course of conduct. We had a course of conduct before, and we have a course of conduct now. It's just not clear that it was Kyle or Angela. So one of the problems is that, or the main problem, is that Judge Mrazek pivots to this analysis of, is it Kyle or is it Angela? And he acts like only one person can be responsible for doing this, whereas in fact, it was likely both. He doesn't ever analyze whether it could have been both. He talks specifically about it was either Mr. Petersen or his wife that did this, and it's not evenly balanced. But we don't know. There's no reason that it has to be Kyle or Angela. And when we look at the entire course of conduct, then I think we should be able to get to the point where we say, well, there's enough here to suggest that it might have been Kyle, but Judge Mrazek didn't do that analysis.
Let me ask you about the petition, and I admittedly don't have it in front of me. On the petition that you fill out for a civil stalking injunction, you're required to identify the course of conduct events numerically. You identify them 1, 2, 3, 4, 5.
Right.
So and I'm asking about the petition, how they were identified here. So obviously the credit card monitoring was identified. Was the prior conduct identified as one of the specific pieces of the course of conduct in this petition when it was presented to the district court?
Well, I guess I don't know if it's on page 1, but it was attached. The first 90 pages of the record are all of that other information.
You can attach whatever you want to a civil stalking injunction, and as a district judge, I certainly saw a lot of things that were attached to these. But my question is whether it was specifically identified by Steve on the petition itself to say, I am alleging that the course of conduct here includes the credit monitoring, 1, and 2, and the numbers don't matter, but the listing matters.
Sure, right.
The text messages from the prior petition. Because it seems to me that might specifically put the district court on notice that the course of conduct here is more than just the repeated monthly monitoring, but it's the monthly monitoring plus the prior conduct.
Well, I don't think there's any question that the court was on notice that that was the allegation. We've got all pages 1 through 90 attached to the old record. Page 208, in Steve's testimony, he talks about Kyle affixing a hate emblem to his automobile. It's brought up in closing arguments. Like, there's no question that was in Judge Mrazek's, I don't want to say it was in his mind. He was on notice that was part of the
Because then he would have
analysis.
considered it, right?
Well, and I mean, it was being discussed.
Well, and that's my
right?
question though, is it being discussed as part of the course of conduct as the basis to issue the injunction? Or is it being discussed simply as background information about the relationship between the parties? And I do think there might be a legal difference of significance between whether it's background information or whether it's specifically identified in the petition as part of the course of conduct.
I don't know whether there's a legal difference, but the background information is what this case law is asking us to talk about, right? It's asking us to look at the context. It's asking us to look at the cumulative evidence. It's asking us to make a holistic, not an insular analysis. I mean, if we're just breaking it apart, then we are doing an insular analysis.
So if the course of conduct in this case then is only the credit monitoring, your position is that the district court was still required to look at any evidence that's presented to it, whether it's attached to the petition, whether it's provided in the evidentiary hearing, as informative about the relationship between the parties and the impact it has on the other elements of establishing a civil stalking injunction. Am I following that correctly?
Well, yes, in part. My point is that the trial judge was focused on it was either Kyle or it was Angela. There's absolutely no reason to say that it was only one person or it could only have been one person, right? The stalking injunction.
But that's independent. I mean, that could be the issue whether there was any prior petition or not, right? The same argument you're making about the either or the both applies even if the course of conduct is only the credit monitoring and there never was this prior petition.
True, but once you say, okay, well, it's not an either or analysis, it could certainly be both. And if we are trying to get past this 50-50 because we're frozen at 50-50, we've got this past course of conduct that we already know is offensive, and we've already asked Kyle to give him a wide berth, and that's enough to tip us over the edge. We only have to get to a preponderance.
Can I ask you about the text messages being in evidence? You seem to be assuming that they were at the hearing.
I believe that they were attached to the petition.
Right.
Right.
But attaching something to a petition, even a verified petition, doesn't necessarily put them into evidence at the hearing, does it?
Well, the protective order document asks you to identify any evidence that supports it. And it uses the word evidence. And then all of that information gets attached, and it gets discussed. So I think that a verified petition where you're asking about, list all of the evidence, I think that is evidence in the record.
I guess the question I have then is if you think the verified petition and all of its attachments are in evidence at the hearing, That's basically just a declaration, right?
Sure.
So why isn't Angela's declaration in evidence at the hearing if at stalking injunctions, we sort of lift the rules of evidence about putting text messages in and we say verified petitions and declarations are in, why is his declaration in Steve's and not Angela's? Remember there was this whole Fifth Amendment thing about whether she was going to testify to the contents of that declaration, and Judge Mrazek had the declaration in front of him and warned her and all this. You know what I'm talking about?
I remember it well, yes.
So why isn't that declaration in evidence just like his declaration is in evidence? And how do you differentiate, how do we get to a place where we can say that the verified petition and its evidence is in evidence, but Angela's declaration is not? How do you differentiate that?
Well, I guess I don't know, but what I do know is that Steve testified, right? And Angela didn't testify. And
Well,
Steve,
he did, but his only reference to the text messages is on record 208, where he says, Mr. Petersen made a number of threats over email.
right? Yes, and
So he's referring obliquely to the text messages, but he doesn't go into detail in this hearing about what they said.
True.
Now, certainly Judge Mrazek may have had some institutional knowledge from the previous hearing, but in terms of whether they're in evidence at this hearing, I guess I wonder how you get there.
well, okay, but even what he says on 208, and he talks about it being a hate emblem onto his automobile, I think that's sufficient to say we have this background course of conduct happening. We know what's going on in the background. And Angela's declaration is only relevant to this, like, either Kyle or Angela type situation. It's not it doesn't say, well, it was, Kyle didn't do it at all. Or
Well,
Kyle wasn't involved, engaged.
This is why I'm asking the question with the backdrop of Angela's declaration in place, because according to Judge Mrazek's sort of summary of what that declaration said, she said, I did it and he didn't, right? And so if that's in evidence, isn't that a problem for you?
Well, but we don't think that Judge Mrazek did identify. I mean, he didn't rely on that, right? She didn't speak. She didn't take the fifth. She just didn't testify, I believe, is my recollection here. She doesn't
She
testify.
testified for about 2 questions.
Yeah, right.
So she did take the stand, take the oath. She was a witness, but then she stopped before she got to anything of note.
Well, right. Judge Mrazek says we don't have any sworn testimony from Mr. Petersen or from Angela. So he certainly didn't think we got anywhere.
Anything substantive, yeah, that's
Anything
right.
substantive. Right, exactly. And then he focuses on the limited evidentiary residence record. Sorry, he finds that Mr. Scmidt failed to carry his burden by a preponderance to show it was Mr. Petersen who engaged intentionally or knowingly in the course of conduct. But he never analyzes this consideration as to whether it could have been both, and he never considers the holistic context, which I think the law requires him to do.
Can I ask you a side question? I know this hasn't been briefed, but I'm wondering about it. There's a few references in the briefing to the fact that there was a criminal case filed. What can or should we do or not do with the criminal docket? Should that inform our analysis at all?
I don't think so, because the criminal docket has a different standard of proof, right? And so knowing what happened in that context only tells us what happened under the criminal standard of proof issue, not under a preponderance.
So we should just leave it
standard.
alone.
I think we should just leave it alone. And nobody's asked you to take judicial notice of it. Thank you.
Great. And we did keep you over time there, so we'll give you your full rebuttal.
Thank you, Your Honors. Emily Adams for Kyle Petersen. Just jumping into some of the questions, I think Your Honor already knows there is a criminal docket out there. Kyle Petersen, his criminal case was dismissed back in June of 2024, and Angela Petersen took a plea in abeyance to identity fraud also in June of 2024. So the criminal case against Kyle is no longer outstanding.
Should we do anything with that or no?
This court can always take judicial notice of
I mean, you
other
haven't formally
dockets.
asked us to. This was just something I was
Right.
wondering about on my own, I suppose.
I don't think this court absolutely needs to, but I think it certainly helps our argument.
And I do have a question about that. I didn't look at the docket beforehand, but was there a protective order entered in the criminal case?
I believe in Angela's criminal case there was, because she took a plea in abeyance, and I'm not recalling Kyle's because his case was dismissed. I didn't look much further than that. Exhibit 6 shows that the monthly charge was $995, Judge Harris.
No, good estimate, Ms. Nelson, $10.
There you go, $10. It was an excellent memory. As for the course of conduct, Judge Oliver, your question about the petition, what did the second petition say? It's on page 5 of the record. It essentially says three things. It says we filed a petition back in June. That petition was denied. And look at this lengthy admonition that Judge Mrazek gave the parties at the end of the hearing. And then it goes on to talk about stalking. It's just, it's about 3 pages of lengthy paragraphs, and it doesn't actually set out the elements, but it seems from that document that it's much more focused on the course of conduct being the credit monitoring rather than anything else. And in fact, on the record, when we get to closing argument on page 236, this is what Steve's attorney says. The stalking statute allows for a course of conduct which is 2 or more acts directed to a specific individual, specifically the monitoring. And then they go on and they talk about this a period of 2 years, it was his credit report. We don't get into the course of conduct being anything else besides that until the court says, well, how do we even know that it's Mr. Petersen here? How do we know that it's Kyle? And then they say, well, we have this other stuff that happened. So the course of conduct was always limited to this credit monitoring, both in the petition and then when we get to the evidence at trial, as Judge Harris has pointed out, and also when we get to closing argument.
But that seems to cut both ways, because if Ms. Nelson's correct in her first point from her brief, that the court was required to consider the prior conduct, the Confederate flag, photo, and so forth, and as you put it now, that the court's just not even talking about that, then that would seem to suggest that if that is indeed a requirement, that it was not satisfied here, right?
If the court was required to consider that full course of conduct, it didn't really matter. Those 2 prior incidents don't bear at all on whether Mr. Petersen, I'll say Kyle, whether Kyle did the Equifax monitoring.
Suppose we think, analytically, suppose we think that the court was required to consider the prior incidents, the Confederate flag photo incident. At that point, would we have any choice in the opinion but to remand and have the court redo the analysis?
No, because I think you can go ahead and do a simple prejudice analysis like this court does in every case. You can look and see if the omission of that was harmless. And it absolutely was harmless here. I first off, Judge Tenney, I think that your reading of the case law is incredibly correct. With Vanderbilt, congratulations. So I think that it's right that when the court is talking about a holistic approach, it's talking about.
It's not the first time somebody said that to me.
Oh, dang it.
I don't know, incredibly correct.
Incredibly correct.
I'm going to make note of that, as I'm sure Judge Tenney will for future
you put it on
reference.
your wall.
Right.
It's that the court, when it's talking about this holistic analysis, it's saying like we're looking at all the course of conduct, not just one at a time. And that was the issue in Anderson v. Dean, which actually was our case. And so the district court was looking at one piece of conduct at a time to determine if each piece of conduct would have caused a reasonable person to fear, rather than looking at all the conduct together.
But why would we segregate it analytically in that fashion? Why wouldn't it look to the question? Why wouldn't it also inform the question of whether the person did this thing here too?
Right. Well, I think the problem is that first we have a pleading problem and an evidence problem in that throughout this case, the course of conduct was identified as the credit monitoring. And that was what they chose to go on. And we also have a law of the case problem, because those first 2 incidents, they said, in their first petition, they said, well, he sent all of these texts, and the texts were not great, but they all occurred in a short period of time over a wedding weekend where this Angela and Steve's son, there'd been a blow up with this teenage son. And so the son had left, and there were these texts between Kyle and Steve about the son leaving, and in the middle of that, we have the Confederate flag car thing showing up. So
right, but Judge Mrazek's, just shooting to the end point of the law of the case dynamic that I think you're getting to, Judge Mrazek says with respect to the first incident in the first hearing that he doesn't find that there's proof that Kyle did the photoshopping, but he seems to assume, if not outright find, I'm a little fuzzing that in my mind right now, but he seems to assume that Kyle did send the text, right?
Oh, well, Kyle agreed that he sent the text.
Okay,
there was
so Kyle
no
agrees
dispute that he sent the text.
So coming back to this problem here, if it's agreed on the record that Kyle sent inflammatory texts before, why wouldn't that inform, as an evidentiary matter, why wouldn't that inform the question of whether he also was engaged in the credit monitoring problem?
Because it's very different, Your Honor. Inflammatory texts on the weekend when a teenage son bursts out of a room in the middle of your wedding is very different than monitoring somebody's
it's certainly
2 years.
different in terms of the conduct at issue, but if there's an underlying animus, why wouldn't it at least inform the question of whether Kyle disliked Steve enough to do something horrible to him? Why doesn't it at least go to intent?
I don't think it goes to intent, Your Honor, especially since we're dealing about completely, I mean, if we're in a 404B evidence area, I mean, it's just so completely different than what we're talking about. It doesn't show motive. I mean, the thing is that the credit monitoring happened in, was it February of 2019? This blow up happened in 2022. So we're talking about years later. And there's absolutely no evidence of well, I mean, there is some evidence on the record that this was I think counsel called it an otherworldly contentious divorce. So this was an incredibly contentious divorce between Angela and Steve. Also, Your Honor, in that prior stalking petition, they argued that, Steve argued, I'm feeling surveilled. I'm feeling like I have surveillance on me all the time. And the court said, no, I can't find that Kyle surveilled you at all. And so.
But doesn't that tie together the two incidents? Because if the first one is a photograph of his car that's obtained within a gated community, that could easily be tied together with some kind of surveillance. Somebody's watching him, taking photographs of him. And then here we have a different kind, but still surveillance, right? You're surveilling my financial activity, what I'm buying, what kinds of things are happening in my accounts. And that's a broader umbrella of surveillance. And so to Steve's point, that is the course of conduct. It's surveillance. It's that Kyle is in my business, right? He's keeping track of me. He's stalking me, right? This is a civil stalking injunction. So it seems to me that might cut against you there because it goes to the broader umbrella view of stalking, right? And surveillance.
Yeah, but they didn't bring that in their petition. They didn't really bring that into evidence at all. And then when we get to the actual facts of the case, what the court heard at that first evidentiary hearing was that the registration sticker on that car expired, I think it was September of 2020. The picture was taken, they think sometime, and Steve left the community in November of 2021, and then the picture was sent in June of 2022. I mean, there just wasn't enough of a link between. It was just it seemed to be like an incredibly
right. And I
from years
understand
prior.
that the first petition was not granted on those grounds. But when you're looking at a course of conduct and what is the conduct that is being complained about, it seems to me that Steve is complaining about being surveilled, right? And when you get down into the nitty gritty of whether you've met your evidentiary burden at the first petition, we can all see how it came out that way. But when you get to the second petition, you're building on, well, there was this evidence of surveillance, and it didn't quite get me there. But now I have more evidence that Steve is participating and surveilling me, and so it's part of this broader picture. And as I understand Steve's argument, it's that broader picture that the district court was required to consider and didn't hear, and that's why the stalking injunction wasn't granted.
Well, the problem is that we still have a law of the case issue. Like the court said that surveillance hadn't occurred. He hadn't met his burden of showing that surveillance had occurred in the first case. And Steve did not ask for those, and I don't know if he could have asked for that ruling to be overturned in this second petition.
Right, but I think we'd have to slice up exactly what the law of the case implications would be. What the court seems to say is that the conduct in front of it alone in the June 2022 corpus didn't get there. But the other side's point is, okay, but if you take that same corpus of facts and then you add in this Equifax problem, now we're in a different place. And so do we really have a law of the case problem at that point?
Well, I mean, they didn't ask for that.
Yeah.
They didn't ask for that. They didn't put on evidence. I mean, that is really what this case comes down to. If this had been litigated differently, this appeal might look very, very different. But it wasn't litigated in a way where they brought in all the evidence like Judge Harris brought in. The exhibits aren't even in. Like, we don't have all those texts. We don't have the picture of the Confederate flag. None of that was part of the record in that in this evidentiary hearing on the second petition.
So is it your position that in a case like this one, they've essentially got to relitigate the earlier incident? They've got to redo the June 2022 evidence?
Absolutely. I mean, the thing is, we can't expect Judge Mrazek to remember something that happened, like 6 months ago. If you want a court to consider something as part of a course of conduct, you have to put evidence on in your evidentiary hearing. I think it would be really unfair for us to say, Judge Mrazek, you have to remember this thing that you decided 6 months ago and incorporate this into your decision-making when they don't ask for it in closing argument, they don't put on evidence, and they don't put it in their verified petition. I just think that they simply did not carry their burden, or they simply didn't ask the court to include this in the course of conduct.
One of the things is zeroing in a little bit. Let's just assume you're right, that this is limited to the evidence and allegations relating to the credit monitoring problem that's discovered in December of 2022. Judge Mrazek himself refers to what he uses the phrase, the one big piece of evidence. And the one big piece of evidence is that it was Kyle's credit card that was being charged monthly, $9.95, as we've learned, but it's being charged monthly for what was it, 21 months? 22 months?
Yeah.
21
About
months.
2 years, yeah.
And as I sit here and sort of just think about the sort of weight of the evidence problem that's really the core of this appeal, a lot of people might miss a charge once or twice, right? 2, 3, 4 times, whatever it is. We're all of different diligence levels with respect to our credit card statements. But I'm struggling a little bit with the idea that he could have 21 monthly charges, 22 monthly charges, and not at some point notice that this thing is being charged every month. And if the burden of proof here, it's not the proof beyond a reasonable doubt, it's a preponderance. I mean, it is a preponderance, but also it's just a preponderance, right? I'm struggling a little bit with how we would say that showing that Kyle's credit card was being billed monthly for 21 months doesn't at least get you to a preponderance, just even on its own.
Well, because you have the evidence that it was her phone number, it wasn't his phone number that was on the account. We have the evidence that she knew Angela's phone number, not Kyle's phone number. We have the evidence that Angela knew Steve's social security number and birthday. Steve testified that Angela had improperly used his social security number twice to get improper loans, although he was cut off pretty quickly by the court. And so we have all this evidence that Angela was the one that she had done this, and also that she had used his credit card in the past, and he hadn't. He didn't know every time that she had used his credit card.
Ms. Nelson's response to that, at least in part, is that there's something of a binary dynamic there going into how Judge Mrazek framed it, which is a lot along those lines, but it could have been both. It could have been both of them. So if it could have been both of them, why aren't we there?
Well, I mean, the rule still requires, the law requires that Steve prove that Kyle knowingly participated or engaged in stalking. And that means he had to be aware of his conduct. And they didn't put on evidence that he was aware of his conduct. They didn't put on evidence of the credit card statements. They didn't put on evidence that Kyle even looked at his credit card statements. There are some married couples where only one spouse looks at the credit card statement. The other spouse just chucks them in the trash. Like, we just have no idea what, if Kyle has, there's no evidence on the record about Kyle looking at the credit card statements.
Correct me if I'm wrong on the sequencing, but these would have been withdrawn before he was married to Angela, right?
Right, but it appears from the record that they were together far before that.
Okay.
There is a notation on the record where Steve says, and let me just give it to you really quickly. He says that I think the divorce has been going on for 4 years, so that would have put us back in, said on page 64 of the record, Steve testified that as part of the divorce litigation in 2019, there were several demands made by Kyle and Angela.
So Kyle's involved with Angela, at least as of 2019.
It appears. I don't have exact dates. Maybe Ms. Nelson has better dates, but at least we have a note that he was involved back in 2019.
I mean, we're kind of back to my question. I mean, you hate to make these things too simple, but it does feel like that's sort of one of the cores of that argument, is that we get to draw reasonable inferences when we're evaluating factual pictures. How reasonable is it to assume that Kyle missed 21 monthly payments on his credit card?
It's also
monthly
reasonable.
charges.
Yeah, I'm sorry, Your Honor.
No,
It's also reasonable to assume that somebody doesn't look at their credit card statement. And so there was no evidence put on that Kyle looked at his credit card statement. They could have called Kyle to the stand. They could have put on some evidence about him looking at his credit card statement or anything like that, but they didn't. And so they just simply did not carry their burden of proof showing by preponderance the evidence that Kyle knowingly did it. Now, what's interesting is a lot of times in the closing statement, they talk about recklessly. Steve says, well, Kyle should have known from his credit card statement, right? This is kind of where you're going, Judge Tenney. Kyle should have known from his credit card statement. But that's a reckless standard of review. We're at knowing. And if you hit reckless, you haven't hit knowing. He had to show that he knowingly was involved, and they simply didn't show that here. Unless the court has any questions, we ask this court affirm.
All right, thank you. Ms. Nelson, you have your 4 minutes for rebuttal.
Thank you. The first thing I want to clarify is that these events were happening simultaneously. The credit card monitoring was from February 2021 until December of 2022, and the nasty text messages were in the summer of 2022. This was not years before. These were happening simultaneously. So at the same time that Judge Mrazek says, Kyle, I suggest you give him a wide berth, meanwhile, Kyle's credit card is being charged every single month with this criminal activity following Steve's credit. That's very important to keep in mind, that these are happening simultaneously, not before and after. I want to look at a couple of points in the record. So Ms. Adams pointed us to page 5. Page 5 is the petition, and page 5 asks the person seeking the stalking injunction to explain what has happened, and it says, please see Exhibit A. And there's a couple of other questions, and it says, please see Exhibit A. And then Exhibit A is what starts on page 5, and it starts off with a discussion about the messages. And the hearing transcript is attached right there. So I think that we have to assume that if you can answer the question with see Exhibit A, and Exhibit A includes all of this information, that it's there. It's presented as part of the course of conduct. So that's one point I want to make. Another point I want to make is I don't think we have any law of the case issue. In fact, Judge Mrazek made it clear to Kyle during the nasty messages stalking injunction. He said, we have had cases bounce back on a second request for civil stalking injunction because this kind of conduct continues, and now the evidentiary record's stronger. If it comes back the next time, the outcome may be different, so perhaps just stop. That is a completely accurate statement of the cases where you're talking about this holistic conduct. But then he didn't jump that over to the next phase, which was only a couple of months later, not a long period of time. I also want to look at page 153 of the record. Not 1,535, there's no page for that. Page 153 of the record, this is Angela's declaration, Judge Harris, and she never says that Kyle wasn't engaged. She says that Kyle was not involved in the setting up of the credit monitoring account. That is not the same as saying Kyle wasn't involved in it over the course of 22 months while it was his credit card statement. Now, whether he looks at his credit card statements or not, American Express assumes that he knows what's going on in his credit card statement. American Express holds him responsible for what's going on his credit card statement.
A couple of sentences there, sorry for interrupting. One of the things that I've wondered about as I've thought about this case is this. What if the evidentiary picture shows that Angela set it up, but then at some point, say month 2, month 3, month 4, whatever, Kyle learns about it. At that point, has he engaged in a course of conduct?
He is continuing to knowing, I don't know if we can say he's engaged in the backwards course of conduct, but as it continues happening for those months ahead of time, sure, of course, it's a crime.
Can you passively engage in a course of conduct? I mean, because the word that the test uses is engages. And engages feels like it connotes some sort of active behavior. So if the only thing that happens here is that Angela sets it up, Kyle finds out about it, but doesn't stop it, at that point, what has he actively done?
Well, I looked up engaged for that exact reason, and Blacks tells us one of the synonyms for it is involved in. So I think if you've got a credit card statement and you know that like your spouse is committing a crime using your credit card, you're involved in it, at least as far as a stalking injunction is concerned. I think it's actually a relatively low standard. And I think that the error was made in focusing on who set it up, who was the driver behind it. Maybe Angela was the driver behind it, but for 22 months, Kyle's credit card is being used.
So if a husband and wife are married and wife finds out that husband is attached to a GPS device to somebody else's car and is following them around, and wife doesn't do anything about it, is wife stalking that person? Wife stalking that person? If she doesn't stop it somehow?
Well, I mean, she might be, but this is where this back course of conduct is coming in, right? Do we have an entire course of conduct, and do we have a harm, right? If the trial judge found that that conduct would cause harm or fear to someone, then yes, and we do have that here. There was nothing that we're talking about today is whether there was harm or fear associated with it. To summarize, I think Judge Mrazek erred in looking at whether it was an either or analysis when it certainly could have been both. They certainly could have been involved. Both could have been involved. When we look at the entire course of conduct, which case law requires us to do, a holistic analysis, a cumulative analysis, in context, whatever phrases we want to pull from the case law, Judge Mrazek erred in not determining that, in holding that it was evenly balanced. That's because he didn't put all of the evidence on scale, and we would ask you to reverse.
All right, thank you, counsel, both for your arguments today and the excellent briefing in the case. We will take this matter under advisement and issue a decision as soon as we are able. Our next hearing this afternoon is at 2:15, so we have a few minutes here. We'll clear out and let counsel and everyone get settled, and then we will return shortly.